The ruling by the Supreme Court's conservative majority to end affirmative action in higher education has opened up new legal battle lines for universities. And Harvard is once again at the center of the debate, with a civil rights group challenging legacy admissions, saying the practice discriminates against students of color and gives an unfair boost to the mostly white children of alumni. Joining me right now, former federal prosecutor Carol Lam and Anthony Coley, a former senior advisor to Attorney General Merrick Garland. So, Carol, first to you here. Supporters of the policy say it builds an alumni community, encourages donations, but opponents say the practice is no longer defensible without affirmative action providing a counterbalance. What's at the heart of this legal argument?
Yeah, and it's important to first realize that this is a complaint filed with the Department of Education. This is not a lawsuit in federal court, as not yet anyway, as the affirmative action case was. But it raises a different issue. There are differences between the two. In the affirmative action case, the allegation was that Harvard was engaging in actually discriminatory conduct. That is, in the admissions decision, they were actually considering race as a factor, and the Supreme Court held that that actually violated both the 14th Amendment and the Civil Rights Act. In this case, what they're alleging is discriminatory impact. That is, it is not a racially based decision, but it has a disproportionate impact on unrepresented minorities. And that is a little bit of a tougher legal road to hoe, because there are lots of preferences that colleges engage in that are not racially motivated, but they have an impact on racial groups. For example, let's say a college wants to diversify itself geographically and wants to admit more students from the Midwest. That may result in fewer underrepresented minorities coming to the school, but it wasn't a racially motivated decision. So the analysis legally has to be a little bit different, and it will depend on what practices the college actually engages in and what their motivations were for engaging in that practice.
So, Anthony, Carol points out the distinction here between the SCOTUS case and this is a complaint to the Department of Ed. Why go that route instead of the lawsuit route?
Yeah, there are any number of ways to get to equity here. And I think what's really important, Lindsay, is for people to realize how we got here and why this is important. At the end of the day, ending legacy admissions in college is not a new or novel idea. Some of the nation's most elite colleges and universities have already done it. We're talking Johns Hopkins universities, we're talking Amherst College and others. What these colleges have understood and articulated is that legacy admissions provides an unfair advantage to students, to applicants from families who are well-heeled, well-off, and in many cases, they don't otherwise meet the academic standards for admission. I'll add one other thing. At Harvard, what the data found is that applicants are 6 times more likely to gain admission to Harvard via the legacy applicant pool than they were if they were ordinary applicants. So what this effort is signifying is that at the end of the day, if race is not allowed to be a part of the consideration in the process, then nothing else should be allowed as well. And this is an effort where I think you're going to see a lot of agreement from both the left and the right, who are coming to say, you know what, judge everybody completely by the merits.
So, Carol, that said, legacy admissions, they're not as explicit as affirmative action in terms of the process and government involvement. So how does that impact the way that a judge or an administration official might view this?
Yeah, I think Anthony's points are well taken. These are policy decisions that I think universities have to seriously consider. On the other hand, we have to consider how much institutional autonomy a university has. I gave the example of geographic diversity that may disproportionately impact unrepresented minorities. What about when a university decides it needs more math majors or more history majors? Do they need to look at the racial impact that that is going to have? I think I'm here as a legal analyst. I think the question is whether what is maybe unfair in a particular instance is necessarily illegal. I think that is the question that the Department of Education is going to have to struggle with.
And Anthony, I think that you and Carol are both pointing out here this sort of brave new world that we're in, right, post-affirmative action, this ruling of what the landscape means now. I mean, do you think with this challenge to legacy admissions here, do you think we'll see more schools and universities just proactively doing away with those programs?
I think so. I hope so, right? I talked about Johns Hopkins. I talked about Amherst. And there's so many others. I think what Harvard and other colleges have got to realize, yes, you can get a good education at this institution, but there are a lot of other places where students can go to get great educations. I went to a historically black college and university. I did that in part because I wanted to be in a place where I was valued, where I was supported. And I think if Harvard doesn't recognize the state of affairs right now, they're going to be left behind. So, yeah, I hope they change.
All right, Carol Lam and Anthony Coley, thank you both so much for your time.